I'm Dr. Nalini Avinash Wagmare, working as an associate professor at the Maharashtra Vidyapeeth, Pune. This is my brief information. Today's our topic is related to law and legal institution in ancient India. In India, also we find an authority like the Manusmriti recognizing the use of the force, state, and dharna by the plaintiff as a normal means of redress, even when the laws courts had been established. Even a jurist like Narada disapproves of force only when the claim is doubtful and the king's permission is not taken previously. The Virgil which the Dharma Sutras prescribe for the murder of the different classes of individuals also shows that for a long time even murders were not recognized as offenses against the state, but as simple tortures, torts where mere compensation had to be given to the relations of the party murdered. So, uh, it is therefore no wonder that we do not find reference to any judicial organization in the Vedic literature, which is at least 1,000 years earlier than the age of Manu. Vedic literature, how nowhere refers to the king as a judge either in civil or criminal cases. Offenses like murder, theft, and adultery are mentioned, but there is nothing to indicate that they were tried by the king or an officer authorized by him. It is only the analogy of later times that may perhaps warrant the conjecture that the king in the Vedic age functioned as a judge in private disputes. A law and legal institution in ancient time, we find the Sabha. It has been suggested that Sabhapati of the later Vedic may have been a judge, but the possibility of his being a governor cannot be excluded. Such slight indicates as exists seem to show that normally it was the Sabha or the popular village assembly rather than the king who tried to attribute when it was feasible to do so. This conjecture is based upon the circumstances that in the Purushasvamedha sacrifice, a Sabachara is dedicated to dharma or law. If the terms prasannin and abhiprasannin really means plaintiff and defendant, they must be referring to those litigants who submitted their disputes for settlement to the village sabha, either voluntarily or because they were too weak to help themselves. Madhyamasi was and rather an arbitrator than a judge. Then Dharmashastra and Arthashastra give information about law and other things, judiciary which exist in ancient period. The Dharma Sutras and the Arthashastra reveal to us a more or less full-fledged and well-developed judiciary. The king was at its head. Uh, he was to attend. He was to attend the court uh, daily to decide the disputes. It was his sacred duty to punish the wrongdoers if he flinched from discharging it. He would go to hell. The thief was to approach the king with the pestle in his hand and confess to him his offense. If the king did not take the pestle from his hand, dash his brains out as a punishment, it would amount to a dereliction duty. King as the fountain source of all justice. The Dharma Shastras and Niti Shastra literature regards the king as the fountainhead of source of all justice. His his timetable required him to spend every day about a couple of hours in adjudication. In the theory, the king could entertain any suit, but in actual practice, he could have looked into only in the important cases from the capital. He was often too busy to do even this and used to delegate the work to the Chief Justice or to some other royal officer. The king was also the highest appellate court. The king was also the highest appellate court. Narada points out how an appeal was possible to the city court against the village court decision, and how a litigant could appeal to the king against the decree of the city court. But whether a king decide a case properly or otherwise, there is no appeal against his decision. Dharma. The king, however, was expected to be strictly impartial in deciding the cases or appeals that came before him. He was to decide according to law, otherwise, he would be guilty. So, dharma or law in India was not measured by legislature. It religious in nature. It was regarded as based upon smriti and smriti, which were regarded as superhuman in origin. If secular, it was based upon custom of universal validity and authority. One Sikh text points out how law is the king of the king. He could not therefore set it aside. The Chief Justice, Pradeep Vivaka, or the Chief Justice who deputized for the king during his absence, was naturally a legal luminary of high reputation. He was to be well versed both in substantive law as well as in law of procedure. He was to be a master in the sacred as well as in the customary law. Then the judicial administration. The most interesting feature of judicial administration was system of the jury. Even the king and the chief justice could not be in the trail of a case if they were not assisted by a panel of 3, 5, or 7 jurors. The number of jurors was deliberately kept uneven to provide for the contingency of a difference of opinion. The jurors differ from their modern counterpart in important respect. They were to be not only impartial but also well grounded in the law. They were to be fearless exponents of what they believed to be the correct legal position. A juror keeping prudent silence has been condemned. If necessary, jurors were to be express their opinion, even if it was in opposition to that of the king. It was their duty to restrain a willful king going astray and giving a wrong decision. A number of famous jurists maintained that the king or presiding judge is to be guided by the verdict of the jury. We may therefore assume that such was actually the case. The only exception was that of difficult case where the jurors could not come to any definite decision. In such a case, the king exercised his privilege of deciding the point according to his own view. In the case of Charudatta in the Nishchakatika would further show that the jurors used to give their opinion about the meant innocence of, or guilt of the accused. The quantum of punishment was often left to the king. Jurors should be as Sabhyas or the Brahmins. The Smritis are almost unanimous in stating that the Sabhyas or jurors should be Brahmins. The study of the Dharmashastra was usually cultivated in the Brahmanical circles, and a deep knowledge of this sacred law was necessary for the proper discharge of duties and functions of the juror. This must be the reason for the usual view of the Smritis that the Sabhyas should be Brahmins. However, the knowledge of the sacred law was not necessary, as when the case concerned the disputes among the cultivators, merchants, and foresters. Dharmashastra writes themselves recommended that the case should be tried with the help of jurors selected from the caste, their own caste, or the profession of the parties themselves. No need to take the help of the higher community. Manu goes to the extent of declaring that if the jurors did not belong to the caste of parties, a proper decision would be almost impossible. We have evidence to show that in the Vijayanagara administration, the jurors were Brahmins, where complicated law points had to be decided, otherwise, they were merchants and agriculturists. Sukra's statement that Sabhyas were to be from all the castes seems to more in correspondence to the usual reality than that of the Yajnavalkya. They were to be Brahmins. Judicial administration, what was the highest court in Republic state can only be inferred. It is not improbable that the president himself might have been the highest judicial authority, or it might have been vested in one of the members of the central cabinet who was in charge of law and justice. It is quite likely that the lower courts in republic were similar to those in the monarchy, which would be now discussed. Like when the kingdom began to be fairly extensive once after 6000 BC, subordinate royal courts began to be constituted for important towns and cities. To judge from the evidence of Arthashastra, they were often located in the headquarters of territorial divisions like Sthana, which include about 400 villages, Dronamukha, which comprised 400 villages, and Karvatika, which was exactly half of the size of the Dronamukha. So here 800 villages, 400 villages, and half of the villages. These courts function under the authority of royal seal and were therefore called Mudrita in later times. There used to be also circuit courts, which were referred to by Narada. Then in provincial courts, during the Mauryan age, these provincial courts used to consist of 3 officers and 3 jurors. Probably under other administration, the official element may not have been so strong. We may well presume that these courts continued to function throughout the ancient period. What was the relation of the presiding officer of these courts with the head of the local administration? We do not know. Then Kantaka Shodhana courts. These were special royal courts of criminal jurisdiction known as Kantaka Shodhana courts. According to Arthashastra, these courts took cognizance not only of the serious crimes against the state, but also offense against the society. Thus, if traders used false rates and sold adulterated goods, charged expensive prices, if the labor in the factory was given less than a fair wage, or did not do its work properly, then the Kantaka Shodhana courts intervened to punish the culprits. Officers charged with misconduct, persons accused of theft, docility, sex offences had to appear before the same court. Then popular courts also existing at that time. In addition to the above official courts, there were a number of popular courts in ancient Indian polity which constitute one of its legal special features. We have discussed Sabha of the Vedic age probably function as popular courts. The Arthashastra polity was highly centralized one, but it left a number of causes to be decided by unofficial courts. Disputes about the boundaries were to be settled by the village elders. Causes concerning the officers of temples, Brahmins, ascetics, women, minors, old, and invalid persons were also to be decided by dharmasthanas or unofficial jurors. What precisely was the nature of these cases and how and why and by whom the Dharmashastras were selected and what was their number is not known to us till today. Then popular courts are for the first time mentioned in Yajnavalkya Smriti. They are unknown to the Dharma Sutras as well as Manusmriti. Whether they were not evolved before the Christian era or whether they were not mentioned as being unofficial, it is difficult to say. Probably the latter was the case. Yajnavalkya mentioned 3 types of popular courts are existing at that time: Paga, Srestha, and Kula. His commentator Vishneshwara expressly describes them as agencies for adjudication other than the official ones. These same courts are mentioned in the same order by Brihaspati, who points out that an appeal will be to the Sreni court from the decision of the Kula court and to Puga court from the decision of the Sreni court. In Vijayanagara administration, these courts were called Amukya or secondary courts to distinguish them from the royal tribunals. Then Kula court. Then what were the Kula court was being defined by the Mitakshara as consisting of a group of relations near or distance. Kulasa means joint families were often very extensive in ancient India. If there was a quarrel between 2 members, the elders used to attempt to settle it. The Kula court was this informal body of family elders, or alternatively, it may have been a court taking cognizance of quarrels arising in family units of 10, 20, or 40 villages. The Gopa of the Arthashastra was in charge of such units of villages, and they might well have had an informal court of their own consisting of family elders. Then Sreni Court. When the effort at family arbitration failed, the matter was taken to the Sreni Court. The term Sreni was used to denote the courts of guilds, which became a prominent feature of the commercial life in ancient India from 500 BC. They are frequently mentioned in the Buddhist literature, and the Mahabharata gives a glorious description of guild chiefs assembled at the coronation of King Dharma. Srenis had their own executive committee of four or five members, and it is likely that they might have functioned as the Sreni court also for settling the disputes among their members. Though mentioned for the first time by Yajnavalkya, the Sreni court might well be placed a few centuries earlier. There is definite evidence to show that guild courts continued to function down the 18th century. In Maharashtra, probably the same was the case in the rest of the country. Then Puga Court. Puga Court of Yajnavalkya consists of members belong to different castes, professions, but staying in the same village or town. If the Sabha or the village assembly of the Vedic period was occasionally settling the village disputes, the Sabha court would be the earlier prototype of the Puga court. Gramavadi of the Taittiriya Samhita would be probably a member of that group. The Gramavriddha court of the Arthashastra would also be the forerunner of the Puga court. Then Puga court later be known as Gota court in Maharashtra. Then in Karnataka, it was known as Dharma Shasana during the 17th century. Mahajanas, elders of the village, and 12 village servants were represented upon it, and it used to decide private dispute, its decision being enforced by the state as a matter of course. The popular village court has played a prominent part almost throughout the long course of the Indian history. Then Panchayat courts. As for a long time, there was a great misconception about the causes that were responsible for the widespread functioning of these popular courts. They were well known to the functioning down to the beginning of the British rule, and they soon disappeared when it was well established. It was therefore argued by Sir Henry Maine and others that the prevailing anarchy in the country, which did not allow any regular royal courts to function at the village level, was the main cause of their existence. As soon as law and order were established in the country, regular official courts began to function efficiently. These panchayat courts naturally died down. Then panchayat courts existing in ancient period, the ancient India appreciated and encouraged the village panchayats and guild courts for several reasons. They encouraged the principle of self-government. They reduced the burden of the central administration, and above all, they helped the cause of justice. The members of the guild or a village panchayat have more or less reliable knowledge of the facts in dispute as the parties belong to their guild or locality. It is difficult for a witness to come to a village court and tell a brand lie in the presence of his compares, whose respect he will be thereby forfeiting. Then Panchas. There was no limit to the jurisdiction of popular courts in civil matters. They could not, however, try criminal cases of a serious nature. Minor offences, including even accidental homicides, could, however, be disposed by them. The parties to a suit had to pay stamp duties. It was 10% in the case of successful litigant, 5% in the case of his opponent. A portion of the income from this source was utilized for a payment to the bailiff and clerk of a court, and a portion was paid an honorism to the panchas. Then panchayat judgment, Mahajars or the panchayat judgment in Maharashtra are seen to be signed by about 30 to 40 panchas belong to different caste and profession, including the village grain sharing, etc. In Vijayanagara period, also panchayat was a different one. If the case required knowledge of law, Brahmins predominated. If the land revenues were involved, the Mahajans were cooperated. Caste disputes were settled by the heads of the different castes in panchayats. Then in Hindu jurisdiction, it insists that trials should be in the public and a case should be normally disposed of seriously, except in the case of urgency. Law's delay has been condemned by the Smriti writers. The executive was not to be interfered with the judiciary. The judges were to be impartial. During the pendency of the suit, they were not to have any private talk or relation with the parties. If a judge was guilty or of foul play, partially of harassment, did not follow the correct legal procedure, he was to be punished. The clerk of the court not taking the depositions correctly was severely dealt with. Then what was the crime and punishment existing in ancient time? In sphere of criminal law also, we have some interesting and important principles enacted. A crime was regarded as committed if there was intention to commit it, even if accidental circumstance resulted in attempt being filed. Abatement, whether by supplying funds or weapons or boarding and lodging, was also punishable. In the case of treason, even the desire to rebel or capture force by force was also punishable. Some crime and punishment as accused could plead self-defense or minority in his defense. Juries differ as to age when a minority could cease to be defended. Some granted absolute exemption till the age of 8, others till the age of 15. Accused was usually entitled to benefit of doubt. Then fines, imprisonment, banishment, mutilation, death sentence were the punishment in Meghal. Fines were most common. Their amount differed according to their crime. Those sentenced to imprisonment were often made to work on roads or in public places, thought that there should be deterrent effect. Mutilation of the hand was often inflicted upon the thief. Banishment was sometimes imposed upon the members of privileged classes. This sentence was imposed upon murderers, traitors, dacoits, persons guilty of sex offenses. Punishment was to be imposed upon the criminal only. His relations were not to be victimized. In ancient India, punishment often differed with the caste of the accused. Lighter punishment were recommended to the Brahmana Kshatriya. In later times, often varied with the caste of the offenders. Then our juries recognized that the sin of the Brahmin would be a hundredfold that of Shudra of the same offenses. Then jails are so called as a Bandhanagara Daksha in Arthashasana, where the Kautilya tells us how he was to be punished if he took bribes from prisoners or belabored them or did not give them their full rations. Male and female prisoners were kept in separate wards. Uh, the plaintiff was first of all jail and jailers and the judiciary system as fine today, that is also mentioned in this slide. So, ordeals were permitted at the time. The ordeals sound strange to the modern era, but it consists even in the present courts under the form of special oath if parties agree to it. In ancient medieval times, the ordeals were fairly common both in Europe and in India, owing to the prevailing belief in divine intervention on behalf of the jurist and innocent. Smriti ordeals were not quite irrational. It was only when no other evidence was available that a party was permitted to establish his case by the ordeal. In the fire ordeal was prescribed in Yajnavalkya Smriti. Then again in the later ordeals by water, poison, weight, etc. mentioned in the text. Then when the evidence was over, the judge would be in consultance with the Sabhyas, juries given his decision. Copy of judgment was given to the parties. An unusual party could appeal to the highest court. Plaintiffs rarely figure in the ancient Indian judicial system. It is argued by some that Manu refers to plaintiff by the term Vipra. Then he points out how the witnesses, the jurist, and the judge labor for others, how Vipra's creditor, the merchant, and king profit in the transaction. This is quite possible, but we cannot exclude the possibility of Vipra referred to here being a member of the jury who might have received an allowances. Then Sukra also referred to the practice of appointing recognized agents in the law courts to defend a case when a party was himself unable to do so, owing to his other preoccupations or ignorance of the law. So that time the law agents were known as a niyogis. Such agents were known as niyogins. And they were expected to guard the interest of their parties very carefully. The lawyer's fees varied from 60% According to value of the property, the larger the corpus of the property, the smaller was the percentage of the fee. Such cases were not frequent, and there is no evidence to show that there was a regular class of persons in ancient India whose profession status were the same as those of modern lawyer and whose members were licensed by the state to follow the profession. So these are the few reference book you can refer for more details. The main Indian history book, Allahabad Law Agency, Altekar book, State Government in Ancient India, ZN, Enza book, Ancient India. So in this lecture briefly introduce about the legal administration in law and legal system in ancient period, only highlighted in this lecture. Thank you.